Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Help! Lucy, you need help? Or are you just here? Hi. I was just giving a pep talk to StreamYard before we began, but I realized that it wasn't a very nice stream or a nice pep talk. I realized also that YouTube Daddy wouldn't let me monetize the video if I started it out the way that I did. So I guess we'll just be thankful that we didn't, and it was only StreamYard that heard the pep talk. Thanks so much for being here. I hope you've had a wonderful day. I would love, love, love for you to tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. I have not had dinner. I have only had caffeine. Some of my best days have been produced with only caffeine and no food. I know everybody else will say, that's not very healthy. But I'll have you know that I got some vitamin D today via the sun. I was instructed by Dr. Google, thank you, MB, to go in the morning sun with no sunscreen for 5 to 20 minutes when my shadow is shorter than my body. I was worried. I'll tell you the truth, because I have been fully trained not to go in the sun. Lots of grilling happening. Sarah, I like that. Grilled ham and cheese. Courtney, grilled chicken leg and corn. Just one leg. And I did that. I did that. I was in the sun. Ooh, taco dip and chips. Lie is too damn to cook. I think Lucy lives in the hot place right now. It's pretty hot, I know, in part of America and Canada, and my feeling goes out for all of you. It is indeed not hot here. I'll clarify that, especially since I went into the heat or into the sun with the UV index. I checked that first. It is currently 67 degrees here today, and so I was fine. But I hope that everybody is staying cool. I dipped into the archives today. I thought, some courts aren't in session today. Part of my brain was not in session today. So we are going back in time to 2023. Lisa Figalicious. It's hot in the sun and cold in the shade. Yeah, we have an ocean breeze. This is a shirt, Vicky, but thank you very much. And in fact, it barely fits. It fits only if you're looking at the top half, but we don't have to talk about that. That's not the point, because you can only see the top half, and that's the point. Anyways, it's Judge Kirkham. It's older, and I want to know if he's gotten crankier, if we remember this, if these are people we've seen before. I want to see what's going on. So, without further ado, also, by the way, this week by accident and like last week, I happened to stream like many, many hours. I didn't really realize it. I was like, why? So many hours, but it was just so many. And it's just because I can't turn it off. Anyways, let's get going.
Everyone's crying.
Yeah. Okay. We got somebody on the move in the jail.
There you go. Thank you. Hey, how's that? Can you hear me?
Yes.
Wonderful.
Do we have the approval yet, so we?
Not to my knowledge. Double check here. Jesus? They change the settings.
It's her voice. She's changing the settings. Oh, what are you talking about, Kelly, with an IE?
Can you come in? Did they change the settings for the chat? Okay.
It's easier to do it by Zoom.
Well, yeah, I don't understand.
Keep in mind, this is still
The chat?
3 years into the pandemic. The post-Zoom era, I'll call it.
I'm live.
You're fucking live, that's right, girl.
Yeah. Well, you heard it used to be.
No, it had, wait, you know, there's a lower thing.
It's like the cheap Alibaba version of Jay Regier. Law AI bot, allegedly.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2014-978 DP, Teresa Green versus Richard Green Sr., intervening party, Jennifer Wolf. Today is Monday, March 13th, 2023 at 9:02 a.m.
Court will note the appearance of Mr. Vanderhorst on behalf of the defendant, Ms. Podolsky on behalf of the intervener. In this matter, the matter is before the court on the intervener's notice for entry of consent judgment. Ms. Podolsky.
Thank you, Your Honor. We were here a few weeks ago and we placed an agreement on the record as it relates to custody, parenting time, and support of the minor child in this matter. We have noticed this up for entry today. We did not hear back from defendant regarding income. We did understand he was on Social Security disability. We used an amount that was known to us from the Social Security Administration as.
Ma'am, are you talking about the guy that's in jail right now? And thank you, Amy. I would immediately recommend going back from last week, a fucking hilarious episode about the chicken ambulance, a law leg, we'll call it that. This chicken had a leg that was in the law. Okay. Thank you again. Seriously, a glory members only episode we had last week. Lisa, I don't know how you can join on iPhone. I know her voice got cringier and cringier. See, cringier and cringier and cringier. I mean, she projects. Jesus is still there, so things are sort of the same. A fucking StreamYard. We talked about this, dude. We talked about this. I said you got to step it up. You got to bring the fucking game today, dude. Please.
Being in the general ballpark, if you will, of a monthly amount. It was just over $300. Unfortunately, I don't believe counsel for defendant had been able to reach him, and because of that, we have noticed this up for entry today.
Okay, Mr. Vanderhorst, so what's your response?
Thank you, Your Honor. In regards to the order does appear to correct what we put on the record and what Mr. Green agreed to. My concern is just I need to confirm with him his monthly Social Security that he is receiving that was put in the Uniform Child Support order, just to confirm that is correct.
Okay.
So,
Mr. Green, are you aware of what your monthly disability is?
I think it's 0 now, Your Honor.
Okay, well. Okay, well, you're gonna have to provide some information to Mr. Van.
No, but he's right. When he's incarcerated, I don't think they pay you your Social Security or disability benefits. So depending on what he's incarcerated for and for how long, it's really, honestly, it's a little bit weird. StreamYard, seriously, smarten up. I'm not kidding right now. To understand how the judge and the court doesn't understand this. He's incarcerated. If he's incarcerated, well, I don't know. There's a reason I'm not a lawyer. Well, there's actually like many reasons I'm not a lawyer. First and foremost, didn't go to law school.
So he can provide it to Ms. Podolsky.
That's gonna be
And
difficult, Your Honor. I'm in a jail cell with no bond.
I understand, but, well, if you can contact somebody to get some documentation or just provide it to Mr. Vanderhorst when you can, I understand.
Not
you're in
likely.
jail. So. Ms. Podolsky, we're just awaiting, front of the court. We haven't had the approval yet, so when we do, we can get it entered at that time. And, Mr. Green, when you can get the income information to Ms.
Still glorious. That's the beauty of court. Don't worry about it, crew. Not even that late. 11 minutes in, I'm usually not even done my intro at this point. But today,
can resolve that issue as well.
No, I can't wait.
Okay. Okay, thank you. Court will end this matter at 9:05 a.m. You're free to go. Have a good day.
Thank you.
Thank you, Your Honor.
When we get the FOC, submit it, we'll enter it, and then what we'll do is then, if we have to modify it after the fact, we'll do that.
Do you know if Nicole Blunt plans on appearing?
She's here with me.
Hi. Perfect. I'm just checking in one person and I will bring in Justin Blunt. Or not
Gordon.
Justin.
unfortunately,
All
it's
right.
already a sassy fucking docket. But Judge has the exact same demeanor.
Please unmute.
You could convince me this was yesterday. You shut up, lady.
Your first and last name, please.
Christopher Depew?
Christopher Depew.
Yes.
All right.
Always
put
with
you
the
in the waiting
angle.
room,
Where are they
okay?
holding the phone?
Okay, thank you.
Thank you. Calling case 2017-3574 DM, Nicole Blunt versus Gordon Blunt. Today is Monday, March 13th, 2023 at 9:06 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, the defendant appearing in pro per. This matter is before the court on the plaintiff's motion for modification of parenting time. Ms. Podolsky.
Thank you, Your Honor. The judgment of divorce in this matter entered in June of 2018. That order granted the defendant father standard parenting time. Since the entry of the judgment, he has not been exercising his parenting time or even a fraction of his parenting time. And in 2022 alone, only exercised 14 overnights. To date, he has not seen the minor children since August 28th, 2022. And he is moved to Indiana. He did that in September of 2022, and his new residence is 2 hours and 45 minutes away from the plaintiff. He made this move without permission from the court. He has not been participating in the medical and educational decisions of the minor children. My client, however, has been keeping him regularly up to date on all of their medical needs, including a tonsillectomy had by one of the minor children back in February of 2022 that the defendant failed to.
What in the crack whore was that? What in the crack whore was that just went behind him? Girl knees. Are you she spends enough time on her knees? She could seriously have done it there. Back. We're going back. Look at this.
Plaintiff. He made this move without permission from the court. He has not been participating in the medical and educational decisions of the minor children. My client, however, has been keeping him regularly up to date on all of their medical needs, including a tonsillectomy had by one of the minor children back in February of 2000.
Some redheaded, here she goes. What's she holding? I'm serious. Get on your fucking knees, girl. I've crawled to the site before. Has nobody else done that? StreamYard, I am so fucking sick of you. I'm not even joking. I'm so sick of StreamYard today.
22 that the defendant failed to attend. He has sporadic phone contact with the minor children. When he does have that phone contact, it often lasts less than 5 minutes at a time. My client has been in contact with the defendant's mother. She organizes visits for defendant's mother, organizes meals for them to have with their paternal grandmother. We are asking this court to modify the judgment of divorce and order parenting time at all.
Is she back carrying a cat? Cat? Hold on. 731. Look at this.
I have with their paternal grandmother. We are asking this court to modify the judgment of divorce and
that's some sort of animal. What the fuck is happening?
orders in places as the parties may agree, because essentially that is what has been happening now since the entry of the judgment. Further, the judgment of divorce does provide language that states the defendant's father can only have contact with the minor children if it is supervised by the defendant. That language needs to remain in any and all future orders due to the nature of his felony convictions. So we're asking at this time that the court modify the judgment of divorce and order that defendant's parenting time occur at all times and places at which the parties may agree, that transportation for his parenting time be provided by defendant himself, and that he is to be present for that transportation due to the language that is necessary regarding his father. And we believe it's important that he provide that transportation because he did make this decision to move without permission from the court, and again is 2 hours and 45 minutes away from the minor children.
Okay, thank you. Mr. Blunt, what's your response to the motion?
Based on what I know of Michigan's family laws.
First of all, excellent. You're speaking to a judge and a lawyer right now, bud. And so I'm going to go with, this might shock him, the judge and the lawyer knowing more about Michigan law than you and your little Google search that I'm sure you did. Because, Mr. Blunt, let's be blunt, shall we? No, like, just do not start. This is terrible. I'm worried for him. I'm worried for him. So,
Last time I checked, as long as the domicile of the children did not.
like as if he went to Last time he checked, well, how about the last time the judge checked or the lawyer checked? Both of them went to law school checking a lot more than you did.
Change that should not have any pertaining to me. Not to mention, as it was either become homeless or I moved, and I wasn't prepared to lose even further rights to my children by becoming homeless.
Okay, well, let's address the issue. I'm not concerned much with your move, but the issue
Right.
is she's asking to modify parenting time that would say that all times and places to which the parties may mutually agree. Is there any problem with that?
No, and as it was, I've made numerous contact times, both by text message and by phone call to Miss Coy about meeting up halfway and even giving gas money so that way she can return back to her homestead.
I'm sorry, what? Did he just say gas points to return to her homestead? I'm not joking. Is that what he just said? We spoke about giving gas points. To get back to her homestead.
When becoming with my parenting time.
Okay. Anything
And
else?
she
that you-
has, and she
Go
had,
ahead.
I'm sorry, my apologies, Your Honor. But she has refused each and every time.
Okay. Anything else?
Yes, also based on with the medical needs and dental and everything else, there was times that she never even communicated to me on half the stuff at all until after it happened.
Okay, well, that's another issue. And again, if she doesn't do that, you have a right to petition the court to enforce that. But based upon what you said, that you don't have any objection to modifying parenting time to say all times and places to which the parties may mutually agree. So if there's no objection, the court would order that, okay?
Well, I have an object to that because that's not exactly fair.
Oh, you are objecting to that? I thought you said you had no objection to that.
I'm sorry, Your Honor, I did not mean to have that come across like that.
Okay. Well, with that in mind, what the court will do is the court will, does believe there's a sufficient basis for modification. Court will send the matter to the referee for an evidentiary hearing. And you'll get notice of that probably the end of this week, sir, and then be prepared to have that particular hearing, okay?
All righty.
Okay.
Your Honor, if I may make a motion at this time that the referee hearing occur in person for all parties. My client is hearing impaired. She utilizes the reading of lips to assist her, and that is very difficult to do on Zoom. So we're asking that any evidentiary hearing be a requirement in person for all parties.
Okay. You understand that, sir? You'd have to come back.
Okay, if that's the case, then I require that this being during the week, Monday through Thursday, because I work Friday, Saturday, and Sunday.
Okay, well, what we'll do is we'll try to accomplish that. If, for instance, if you get a hearing notice and the referee sets it for a Friday, then what you're gonna have to do is contact Ms. Podolsky and we'll try to move that, okay?
All righty.
So we'll set it, Ms. Podolsky, you can why don't you do that, put it in an order that there'll be a referee hearing, because we'll refer it to the referee, but if you put that it would be in person and that it would occur Monday through Thursday, then hopefully we can eliminate that conflict with Mr. Blunt's schedule as well.
Okay, thank you.
Okay, thank you all. Court will end this matter at 9:13 a.m. You're free to go. Have a good day.
Thank you.
Thank you.
Okay, Kelly, I'm bringing someone in. Kelly, is Lewis Adams going to be appearing?
I was hoping he was. We did make a reminder call this morning. We have not heard back from him, so I don't know if he got called into work or not.
You have someone I need to identify here, so.
Ooh, he has a job. Oh, sexy. Based
Okay,
on
I
the
do
court
not
that
have him in the waiting room. Would you like me to call that case or would you like me to wait?
I guess we can go ahead and call it. That's fine.
Brittany?
Yes.
Yeah.
Yeah.
Yes.
Good morning.
Good morning.
Good morning. Brittany's joining.
Hi guys, what's up? Come on, cringy,
Brittany,
call a
please
case.
unmute.
But now I'm muted, but now I'll mute.
Can you hear me, Brittany?
I can.
Okay, calling case 2022-3374 DM, Lewis Adams versus Brittany Adams. Today is Monday, March 13th, 2023 at 9:15 a.m.
Court will note the appearance of Ms. Podolsky on behalf of plaintiff, Ms. Henderson on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, exclusive use, return of property, and other relief. And the court does note that Ms. Henderson has filed an answer. I've reviewed that. Ms. Podolsky, you can proceed.
Thank you, Your Honor. I would note that this was filed on February 7th. The court was kind enough to allow us to schedule this for a Wednesday motion hearing on February 22nd, but due to the ice storm, we did have to cancel it and it was rescheduled for today. These parties did reside together up until the time of filing and February 6th, 2023. They have 2 minor children together. At that time, the defendant did move from the marital home. I do not believe there is a dispute over awarding exclusive use of the marital home to my client. I believe that has been resolved. However, as it relates to custody and parenting time, there is no order in place. While these parties have been able to somewhat work together, a specific schedule does need to be ordered. These parties have both been with the minor children since birth. However, it has been the defendant who has absented herself from the home over the years for significant periods of time, with one period lasting up to almost 1 year entirely. The plaintiff has been the primary caretaker of these minor children. He has been able to ensure that they are cared for while he is at work. He handles their schooling and all of their medical needs, despite the fact that he does have a full-time job that sometimes has some weird hours because it is factory work. However, he does have family in the area who are able to help him when he does have to work. The defendant, to our knowledge, does work at a restaurant. She often works late nights because of the hours of the restaurant. We do have a proposed schedule outlined in our motion that we believe would be in the best interest of the minor children and also accommodates the work schedule of both parties. As previously stated, it has been the defendant who has absented herself from the home. It is leaving plaintiff to be the primary caretaker for these children. We do believe it is appropriate at this time to award the parties the joint physical and legal custody of the minor children. We are asking for the parenting time schedule that we've outlined in our motion to be ordered. When the defendant did leave the home, she took almost everything from the home, all the way down to the bath towels and the dishes in the house.
Ooh, that's not nice. I left my ex-husband and I let him take every single thing he wanted. I literally said that. I was like, hey, like, I'm going, like, when we split up, I literally said, I was like, you can literally have every single thing in this house. Every single thing. I don't think that's cool. You shouldn't. It's especially the bath towels, girl. Now, here's the thing. If she was with the kids and had taken everything, part of me understands that in a way. Like, yeah, okay, you have all the kids and you have all the responsibilities and all the shit, and you have to deal with the new place. But if she doesn't have the kids, girl, we got questions. Also, I haven't decided what gram of shatter I'm gonna buy this week, but I'm excited to pick one. I'm jealous of everybody's pens they're vaping.
We do have photographic evidence of this. My client is currently working on a list of property that he would like returned to him. And I do believe we can work that out with defendant's counsel to assure the return of any of that property. So today, I believe the issues that do need to be addressed are custody and parenting time and child support.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. That is correct that we are not contesting exclusive use being granted to plaintiff. My client has no desire or plans to return to that home that is owned by plaintiff's father. It is untrue, Your Honor, that plaintiff has been the primary caretaker of the children. The children are currently 9 and 12. My client has arranged her work schedule to be flexible enough to be able to get the children to and from school. And then she has family members watching them a couple nights a week that she does work. She never works past 9 o'clock. She is able and fit to provide care and custody for the minor children. We outlined in our response to the motion, Your Honor, plaintiff's work schedule that is on average 100 hours a week or more, where he leaves the house early in the morning, does not come back until 11 o'clock in the evening at night.
I did have one job where I worked 80 hours a week, but it was only in the summertime, and then in the wintertime, I didn't work at all. But I'll tell you, working 80 hours a week is exhausting, demanding, grinding, will kill you. But I did it because basically then during the school year, I wasn't working. And so I could spend all the time with my daughter. But during the summer months, I worked literally 6 a.m. till past midnight usually. I was off and on call during a lot of the day and working from home, luckily back, even though it was in the earlier 2010s, but still, that's a lot of work, especially if you had to be at a workplace. Luckily, like my office was at the cruise ship terminal and at my house.
He works most weekends, and so far since the separation, any time that he was not working and asked my client to see the children, she accommodated that. So essentially, if he is granted joint physical custody, the children will be in somebody else's care rather than his care, simply due to his unavailability. He works in a factory with mandatory overtime. It's not something he can flex or
Mandatory overtime up to 100 hours a week? I'm sorry. Please tell me which. This is in Michigan? That's legal? He better be getting paid a lot. I can tell you right now. Like I said, I did that job because I got paid all year as if I was working 40 hours a week, but I worked 80 hours in the summer and no hours in the winter. I don't know how it could be worth it unless you're getting paid so much money.
change his schedule to accommodate the children. My client is able to do that. We provided her work schedule in our response to the motion. She works Wednesday, Thursday, Friday, and Saturday nights. And she is able and I'm sorry, she works Thursday, Friday, and Saturday from 4 to 9 p.m. and the first Sunday of every month from 10 to 3 p.m. And at that time, the children are able to come to work with her and do homework and whatnot, be supervised at that time. So Your Honor, my client is absolutely able and willing to provide care for the children. Previous separations of the parties occurred prior to filing for divorce. They were all due to domestic violence against my client by plaintiff. There is currently a personal protection order that entered by this court and was served upon plaintiff last night. So, Your Honor, that should absolutely be considered by this court in making a determination on custody and parenting time. As it relates to the property issues, Your Honor, my client moved out in the beginning of February after filing. Since that time, we have been asking for a list of property that Mr. Lewis Adams would like returned to him. We have not received that list. My client left children's furniture in their bedrooms. She left a one-bedroom set. She left towels and kitchen utensils and other household items, as well as a dining room table and chairs. She did not clean out the house as stated in the motion. She took approximately 1/2 of the household items, enough to get by and enough to provide for the children. There's children's items left in the marital home as well. So, Your Honor, we are disputing that portion of the motion at this time. We're asking that my client be granted physical custody of the children, with plaintiff having parenting time when he's available to provide care for the minor children. Again, that may be difficult for the court to determine given his 100 hours plus per week of work time. We're asking that child support be granted in accordance with.
That's him. Oh my God. I went and lit the barbecue and I come back and that's him. Oh my God.
The Michigan child support formula. We're not disputing exclusive use. At this point, we are not disputing joint legal custody, as we understand that is the default of this court. So, Your Honor, joint physical custody is not in the best interest of the children. We're asking that my client be granted physical custody. One other portion of the motion was related to Concord schools. We're not objecting that the children remain in that school district. In fact, my client secured her housing within about a mile from the marital home so the children could continue attending that school district. So that is not something that we are contesting at this point. Thank you, Your Honor.
Thank you. Anything else, Ms. Podolsky?
Thank you, Your Honor. Since the filing of this motion, my client has been able to change his work shift to the first shift at the factory. As you can see, he's trying to connect to audio and he is at work right now. We deny that he is working 100-hour weeks. Yes, there is overtime at work. However, it is never a guarantee, just like any job. We do believe it would be very inappropriate for these minor children to be going to a restaurant and bar to do their homework and wait for their mother to get out of work.
Oh man. And many kids did their homework. Am I right, Lisa? Am I right? Thank you so much. Boo! Thank you so much. And you don't feel sad for me about not being able to visualize anything. I've never been able to visualize anything, so I've figured my own way out. Oh, that's interesting. And see, I've never, somebody could tell me that, but like the picture it or like worry about it like that. Right? It killed my last brain cell. Ooh. Do 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 do. So late on that one. Thank you for Productions, Jonathan Hart. Thank you. All right, let's continue. He does look like a bear. Apparently, he's got a good ass job. Oh, we're not quite ready yet. So thank you. And that's the truth, isn't it? Oh, the camera's not. Camera work. That's the truth. You don't really miss it. I have my own way. So I can like intellectualize that they fucked, and that can gross me out intellectually. Jim, thank you so much. Do. Thank you. I appreciate you so much. And Lisa, you did it. You did it, baby. You did it. And it's a right to work state. Yeah, I guess so. And here's the thing. I just want to make sure when people fucking work hard, they get paid. That's all my problem is. As long as you can get paid, it seems to me like you should pay somebody OT for when they work OT, you know? Thanks, guys. All right, let's go. I'm going to go put a burger on the barbecue.
We do believe what is in these children's best interest is to have a schedule of joint physical and legal custody with the schedule we have outlined in our motion to accommodate the work schedule of both parties. We deny that there has been any domestic violence in this matter. I understand, as counsel has stated, that a PPO may have been served last night. I have not seen that PPO. I understand that one was requested and granted several weeks ago, actually back in February, but was never served on my client until apparently last night, the night before this hearing. Since the entry of that PPO, however, the parties have been having parenting time exchange and cordial communication regarding the minor children. So I just find it interesting that she waited until the night before this hearing to serve that PPO. We do believe that is disingenuous. So we are asking this court to enter an order of joint physical and legal custody with the parenting time schedule that we outlined in our motion. We'd agreed to continue school at Concord Schools and exclusive use of the marital home to my client.
Okay. Well, apparently it's not in dispute is that the children would stay in the Concord School District, so the court will order that, as well as grant plaintiff exclusive possession of the marital residence. As that's not in dispute, it's not in dispute either that the parties would have joint legal custody. So the court will grant that as well. As it relates to the physical custody, what the court's going to do in this matter, the court is going to grant joint physical custody to the parties based in parenting time based upon any schedule that the parties can arrive at as mutually agreeable. If they cannot agree, then it will be alternating weeks on exchange on Friday at 6 o'clock p.m. through the following Friday at 6 o'clock p.m. Support will be consistent with the schedule and the guidelines in this particular matter. The court will not take any preliminary matter as it relates to the personal property, allow the parties to attempt to work that out. If they're not able to work that out, then we will address it at a future hearing. So, Ms. Podolsky, you can prepare that order and submit under 7-day notice.
Thank you.
Okay, thank you. Court will end this matter at 9:26 a.m. You're free to go. Have a good day.
So they got half and half basically. He's very fair. He is very fair.
Kelly, Coy v. Coy, do you know if Natalie plans on it here? No, yes, I have Natalie.
Okay.
Attorney Fisher. And let's see, Michael. Maybe with.
Natalie, that's a bad wall to use, honey.
Yeah. All right, Attorney Fisher, please unmute.
I'm unmuted.
All right, calling case 2022-830-DM, Natalie Coy versus Michael Coy. Today is Monday, March 13th, 2023 at 9:27 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Mr. Fisher on behalf of defendant. This matter is before the court on the plaintiff's motion to enforce judgment of divorce, sale of real estate and other relief. I've read the motion. I've also reviewed Mr. Fisher's answer in this matter. Mr. Fisher, when I review the answer, a little bit nebulous as to when your client is going to be able to, again, you said he couldn't file the taxes until he had the money to pay those, and that was preliminary to his refinancing. When's the, I guess you'd say, a drop dead date that he's gonna have that filed, done so that he can refinance?
Well, he did have his tax returns prepared. He didn't get a 1099 until mid-February, so
I was asking about when he's gonna file them. I don't care when he had them prepared. I understand he did that.
he has to raise the money to file it, and what he's asking for is an extension of 90 days, because during that period, not only does he raise the money, but then they have to give the final approval, and then they have to schedule a closing date.
So you're not asking for an extension of 90 days, you're asking for 90 days from today's date?
Yeah, that's correct. And Your Honor, if I may say so, part of this problem is not the problem of the people that are in this hearing. It took 52 days for the judgment of divorce to be entered. And almost all 99% of the judges I am acquainted with always say 60 or 90 days after the entry of the judgment. This one, to my chagrin, said December 31st. So it took 52 days to get the judgment entered. It was not entered. The settlement was in September. It was not entered until November. I didn't get the judgment till November 9th.
I'm your bud. Don't call out delaying logging shit because the judge actually worked them every single day and he likes them. I guarantee it. You're calling out Jesus or somebody for fucking up, and that stays in the grand scheme of things is fucking nothing. File your fucking taxes. I'm sorry. He doesn't give a shit. File the taxes.
Until they had a copy of the judgment and a copy of the warranty deed. And that's the problem. We, right now he's at the finish line. He's done everything. He filed the application 30 some days before I got the judgment.
Okay. Ms. Podolsky, what's your response to Mr. Fisher's answer?
Thank you, Your Honor. We mediated this matter back in September of 2022. The December 31st deadline, that date was a mediated date. That was agreed to by all parties, including defendant. And in agreeing to that, that's giving assurances that he has the credit score, the funds available, whatever he needs to do to get this home refinanced. And that is the mortgage and the home equity line of credit. Mr. Fisher has outlined a timeline in his response. You can see that the deeds were all prepared, signed, entered, and recorded at the Register of Deeds. At this point, we are now at March 13th. So even with the judgment of divorce entering back on November 3rd, we're at March 13th. And this is still not done. And the defendant is now requesting 90 more days from today's date. In the meantime, the home equity line of credit, the mortgage continue to sit on my client's credit report. This is prohibiting her from making her own purchases, securing her own permanent residence because this has been outstanding. We will acknowledge that the skid steer was refinanced, or the loan at least was transferred out of my client's name after the filing of this motion. So that is no longer an issue, but we are asking this court to order the sale of the marital home. This was all negotiated at mediation. The possibility of this refinance not occurring and how the sale of the home would then proceed and what each party would receive from the proceeds of the sale of the home. So we're asking the court to enforce the judgment and order the sale of the home.
Your Honor, if I could just quickly, and I mean quickly respond.
Mr. Fisher, I don't need anything else. Thank you. What the court's going to do is court notes that, and court does note that it was by agreement, but court also notes that things come up and sometimes the refinancing cannot occur for various reasons, which is obviously what's occurred here. what the court is going to do is the court will grant the defendant's request for an additional 90 days from today's date. And if in fact the refinancing doesn't occur within that 90 days, then the court would order the sale of the property on that 90 after that 90th day. So, Mr. Fisher, I'll ask that you would prepare that order and submit under 7 days.
Thank you, Your Honor.
Thank you. Court will end this matter at 9:32 a.m. You're free to go. Have a good day.
Thank you.
You too.
Okay, I am going to read.
This on Adams.
Yes, but she just disconnected, so I will bring in. Open shaver. I'm finding fine. Like we do not have these present. Tom, can you hear me?
I can hear you.
All right, Attorney Toth?
Yes, ma'am.
All right. Calling case 2021-3007 DM Elizabeth Klein versus Matthew Klein. Today is Monday, March 13th, 2023 at 9:33 a.m.
Court will note that this matter is before the court on the plaintiff's notice for entry of judgment and the UCSO. Mr. Schaefer has filed kind of extensive objection to that. Mr. Toth, if you would, I guess, address the objections and then we can go from there.
I will do so, Your Honor. I've had an opportunity to review the objections that I received Friday afternoon, and I've had an opportunity to go back and look at the what I'm going to call the video transcript. I guess we have the advantage of being able to go back and look again at exactly what Your Honor said. I think, first of all, Your Honor, what I would like to do is to focus on the equalization of the parties, because quite frankly, I think we're actually $32.89 apart. And I'll explain why. Mr. Schaefer's, what he calls his judgment of divorce equalization chart, does not include the award of attorney's fees to his client. If we look at the bottom of the chart where it's $1,342.20 awarded from plaintiff to defendant, what that represents is the Cigna stock. It's the same number. In my view, the $5,000 should be added to that also, because there was an award of $5,000 that was directed to his client. And Your Honor, then unfortunately, what Mr. Schaefer's equalization chart totally ignores was contained on page 8 and 9, even of his proposed judgment, and that's the reimbursement from the defendant to my client for expenses. And the amount of that was $12,556. And that's consistent in both of our judgments, Your Honor. I should say that I went through each of the individual provisions within our judgment, and the numbers are the same. It's the way that Mr. Schaefer has chosen to allocate and apparently ignore. So my view, Your Honor, is this, is that Mr. Schaefer claims that it's $8,571.38 that's owed to the plaintiff, my client, by Mr. Klein. He ignores the $12,556 that is owed from the defendant to the plaintiff. And if you add those numbers together, it's $21,127.38. And if then we subtract the $5,000, the attorney fee that's owed by my client to Mr. Klein, we come up with $16,127.38. Your Honor, my bottom line the bottom line equalization number was $16,094.11. That's $32.89 difference. My number is actually more favorable to Mr. Schaefer's client than his. Again, we're talking $32 or $33. So in essence, Your Honor, when we went at it two different ways, and it's unfortunate, but it's consistent with this case. The parties have trouble doing things according to the same process, and apparently the lawyers do also. I've gone through, and I don't quite understand. I understand that maybe Mr. Schaefer missed the reimbursement from defendant to my client, but what I don't understand, Your Honor, is somehow the notion that the attorney fee should not be offset. And I had an opportunity to go over the video, and at the outset of the hearing, or of your finding, Your Honor, you said, and I'll quote, "After considering offsets in the debt in this particular matter, I will tell the attorneys, I am not going to give you a balance at the end saying this is the amount. You have to go through and take each item of property individually and then offset those to come up with the final number in the end." That was at the outset of the property finding in the case, Your Honor. And then I'll jump to the very end of the proceeding, and that happened at the 1 hour, 30 minute, and 34-second portion of the hearing. And this was a situation where Mr. Schaefer was asking for clarification about the attorney fees to be paid. And Your Honor stated, and this is specifically, again, I'll quote, "Well, what happens is we are going to have to calculate and offset all these things. So I don't know, but the court would order that would be paid within 90 days from today's date." The court referenced offset at the very first moment of your finding, and pursuant to the question from Mr. Schaefer, the subject matter of offset comes up again. So as a consequence of that, Your Honor, my belief again is that why aren't we including the attorney fee in the offset? It's illogical. Everything else, Mr. Schaefer or the defendant agrees should be subject to offset, but it's that one item that isn't. And it's illogical, Your Honor, and it's absolutely inconsistent, not only with the theme that you identified for us when we first appeared before you, but it's also contrary to the specific answer to the inquiry by Mr. Schaefer. And I'll simply repeat that I will tell the attorneys I am not going to, well, I'm sorry, it goes back to the 1:30:34 portion of the hearing, and we're going to have to calculate and offset all these things. And that's exactly the way I approached your finding, Your Honor. And again, I think that if we include the $12,556 reimbursement from defendant to Ms. Klein, and if we offset the attorney fee award, our numbers are very, very similar. So I would suggest, Your Honor, overall, we've arrived at the same place. And Mr. Schaefer would, again, I don't understand why the offset would not apply to the attorney fee. So that would be my overall general impression, Your Honor. I would state that there's been no objection that I think we both have the same numbers for the two child support orders. And now I would move on to spousal support. Your Honor, I went back and listened to the video, and I will concede that at that point, or in regard to the spousal support, quote, "The court will grant to defendant transitional spousal support in the amount of $36,000 in gross payable at a rate of $1,000 per month. This amount is not subject to modification, is forever barred after the 36 months." So the form that I submitted and that was objected to talked about termination at death or remarriage. I'll acknowledge that was not in the video. As a consequence of that, Your Honor, I would look at it as follows. If in fact it was the intent that that's an alimony and gross award, I think the easiest way to handle the $16,000 $94.11 offset would be to offset that against the alimony. It's a lot cleaner and it's a lot easier, and it really addresses this argument regarding the various tax rates. So if it's an alimony and gross award, there's no reason that shouldn't be included in the offset. It's a lot easier than the gross up or the gross down, or however you want to look at it, comparing the pre-tax dollars to the post-tax dollars. So I think that that would be, again, the cleanest and the easiest way would be to simply have that money that's owed after it's all said and done of the post-tax dollars of $16,094.11. It could be just offset against the alimony, and we don't have to go on to the adjusting the retirement award. It could remain at that $41,000. Now that brings me to another objection that's been stated by Mr. Schaefer, and that's number 6. And it has to do with the gross up, if you will. And that is that he somehow believes that it should be a 12% rate of the defendant. Well, Your Honor, the actual rate is not 12%. And I'm quoting the Internal Revenue Service, and this is available to everybody. And from the actual rate is 22% for Mr. Klein, because he earns more than $41,776. So somehow, if his tax rate should apply, then it actually should be the 22%. And when you add in the state tax,
Right? I was like, hold on. He makes more than 41,000 and more than what? That can't be the higher tax bracket. I'm fucking baffled right now. I thought we were talking about millions of dollars here, you petty fucks.
my 25% that I used is actually a good number. Actually, it's favorable to him. But that being said, Your Honor, it really makes no sense that we're talking about using defendant's tax rate for anything. And again, I want to be clear that the reason that this is an issue is because at the end of the day, my client owes the defendant $41,000 or such in pre-tax dollars in retirement. And Mr. Schaefer's client owes my client approximately $16,000 in post-tax dollars. And so we come up with our apples and oranges evaluation of this. So the question becomes, what is the amount of money that's going to have to be paid that would provide my client with the $16,000 in post-tax dollars, since it's coming from pre-tax dollars? So again, this is all applies to the plaintiff. It has nothing to do with Mr. Schaefer's client's tax rate. And so the idea here is what we have done is to say that to get the equivalent of the $16,000 in retirement money, it has to be grossed up. And that's basically what I did, Your Honor. I used my client's federal tax rate. I used the state tax rate, and she works in the city of Battle Creek, and so she has the 1% tax. Again, the 25% is more favorable to Mr. Klein than if we took the specific tax rates. But we're willing to go with the 25% if the court is so inclined. And so to try to synthesize what we're talking about, Your Honor, is I would say, number one, Mr. Schaefer and I are on the same page with ultimately the amount of money in post-tax dollars that are owed by Mr. Klein to Ms. Klein. It's, again, he's not willing to go along with this notion that the court on 2 occasions specifically made reference that these numbers are to be offset. So that's number one. Number two is now we're talking about how is that money going to get paid? In my judgment, I said that the offset should be against the retirement. However, based upon the objection filed by Mr. Schaefer, if we're talking about alimony and gross, I think the far easier way would be to simply offset $16,094.11 against the alimony obligation. And then we can give up talking about gross ups and whose tax rate should be used. If the court is disinclined to go that way, then it's illogical that Mr. Schaefer's tax rate enters into any of this, because it's the impact on my client that we're talking about. If the court is inclined to use the tax rate of Mr. Klein, I go back to the IRS tax table, and this additional income to him based upon his current rate of income, the federal part of that would be 22% alone, and then we move to this up to the state level. And I think that again, the easiest way would be to offset the money against the alimony. However, if the court's not so inclined, I'd argue my client's tax rate should be used. If Mr. Schaefer's client's tax rate is going to be used, it starts at 22% and not 12%. So I would move on. We've talked about the attorney fee. Clearly, the ruling of the bench was offset should be work in this case. And again, I go back to the very end where the court made it clear, pursuant to Mr. Schaefer's question, that the attorney fee was going to be subject to offset. We talked about the Cigna stock awards, and I went back and looked, and Mr. Schaefer is correct as to the years that were talked about. I don't think it makes a difference, because in regard to the Cigna award, that was an area where the court was absolutely crystal clear on the amount of the stock that his client had an interest in. So as the court made its ruling, there was a specific number that was used, and that was the $1,342.20. Both of our judgments identify that fact. It was simply the continued statement when we're talking about the Cigna stock. And again, I went back and looked at this, and the court first of all identified that one quote, $1,342.20 would be payable to the defendant and plain
Per fucking month, bud? Per fucking month? This is terrible lawyering. They're rambling about something. Honestly, the only reason we're still watching this Navarre's police videos is because I am still barbecuing and I don't have time to just go through it. So as soon as my burgers are off the grill, we'll come back together and sort it out while I eat this hot meat in my mouth.
plaintiff, my client, is entitled to 2 additional stock distributions, one on March 1, 2024 and one on March 1, 2025. I added in 2023. I'll acknowledge that. I think it should be included. I don't think at the end of the day it makes any difference as it relates to the objection. The page 2, the communication regarding how these parties are going to try to communicate. Again, court, quote, the court would order that the parties would communicate through an app, and I will leave it up to them, whether it is Our Family Wizard or WhatsApp or some other third-party app. If not, they can bring the matter back. That was what the court said, and if we're going to have to come back to court to identify what app we're going to use, then so be it. So I would acknowledge that that was the ruling of the court, and my order was specific. I wish there was an alternative that was suggested by Mr. Schaefer, to be totally honest, but that hasn't come forth. So that addresses the communication. I will acknowledge again that the court did not say we're going to use My Family Wizard, but so that needs to.
It's Our Family Wizard. First of all, hashtag not a sponsor yet, but I've literally written a really good ad copy for that already. And secondly, the other version is the free version. It's called App Close. Okay. I know that, sir. Why don't you? I'm not a lawyer in Michigan. I'm not a lawyer anywhere.
Be changed. I've already talked about the equalization. The Mr. Schaefer's objecting to the support, but again, the court was very, very clear. And I guess he's waived that objection because he hasn't objected to the support orders. But the court made it clear that what it had in front of it was the 2021 income. And I went through and looked at the exhibits that were admitted into evidence, and there was no year-end 2022 that was admitted into evidence. And the court said, well, if Mr. Klein moves, you'll have to come back in. And so if the idea here is if these objections are that this judgment has to have full fidelity to every word that was said during your ruling, then I would say that if the 2021 income is appropriate in establishing support, and both of our orders actually reflect that. I think that leaves us with the we've talked about the equalization amounts. That leaves us to the personal property. So in regard to the personal property, Your Honor, and I would reference, it was 12/14/22 hearing, beginning at page 85, where I was cross-examining Mr. Klein as it relates to the property. And I'll now refer to your ruling on the 14th of February. And it's, and I'll quote, plaintiff has complained that she didn't receive all of the items on the list that she was to receive. The chop saw, the other was a Milwaukee grinder, there was a leaf blower, and I believe there were a couple of other items as well. And I'll say that again, I believe there were a couple of other items as well. And those are the items that I addressed during my cross-examination of Mr. Klein. And what I would say is that my judgment included the items that were referred to during that cross-examination. And perhaps the easiest is the ratchet straps on page 91 of the transcript from.
No, 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 no. In no world is hiring a lawyer a better idea than buying your own fucking ratchet straps, you cheap sons of bitches, you petty assholes. No, I disagree. Like, that's out of control. My burger is delicious, but you people are petty as shit. Okay? This might go into the record books along with the people that split the meat in the freezer. Remember that episode? Hot meat.
On the 14th of December, Mr. Klein goes on to say, give them all to her if it makes it. So I included those items that were referenced on that particular date. The keys to the Raptor, the testimony is that Mr. Klein had the title and the keys and we wanted them back. And I included that. And I would say, Your Honor, that I did then bring that up after your ruling, and I had a question in regard to the Raptor. The testimony was that both the title and the keys are within the defendant's possession. Could the judgment provide that those items be turned over within 30 days? Your response was, quote, you can include Mr. Toth in that standard provision about the parties cooperating. Well, I didn't include it in that paragraph. I included it just on the list of personal property. Keys and a title are personal property. So I'm not sure if the objection is that I didn't include the Raptor title and keys in another portion of the judgment, or if it's that his client shouldn't have to turn it over and or it shouldn't be referenced in the judgment, Your Honor. So, Your Honor, my belief is that the court made it clear that there were other items that my client claimed she didn't get, and that's why I included those in the judgment. So what took us, Your Honor, the better part of a year to get through with testimony, I think now there are extensive objections, but I think we really have an opportunity to simplify this. If we offset attorney's fees and if we offset the Cigna stock, and if we offset what the defendant it owes my client against the alimony award, then we can just simply have the $41,000 transferred pursuant to the language that you had in your finding on the retirement money, and that makes it easy. If we're going to go the transfer pre-tax dollars to my client to make up for post-tax dollars, there has to be a gross up. And I've identified 3 ways that I've looked at it, and I don't think any of them make a heck of a lot of difference at the end of the day. I would, Your Honor, like an opportunity at some point this morning to have the court offer some clarity on perhaps another issue, and that has to do with the parenting time schedule. Your ruling changed it. It was actually just about a month ago. My experience over 35, 36 years, however long it has been, is that when a judge makes a ruling from a bench and on a parenting time schedule, the parties adopt it. Consistent with everything in this case, Mr. Klein insists that until the judge's name is on an order, that the temporary order applies that relates to parenting time. So I would ask, Your Honor, whether it's now or whether it's some other time, if the court could offer some clarity, because it's creating another huge issue. My position is simply that the court's identified what the schedule should be. It should be effective now, because it could be another month before we get this judgment signed. Thank you.
Okay, thank you. Mr. Schaefer?
Your Honor, again, I guess the history of this is that it took us the better part of the year to try this thing. There was a lot of testimony. And I guess let me address the argument of easy versus what was ordered. The 2 items, the attorney fees and the spousal support. I believe that Your Honor's ruling was the offset of property. That's what Mr. Tove read when he went back. This is not property. And there's a distinction. Easy is not the remedy here, is that the attorney fees and the spousal support were there to assist current money obligations. Especially the spousal support was a transitional time period because of the lack of income and the lack of property that he was awarded in this particular matter. To say, oh, let's just set it that is easy, does not help out the current cash flow. And that's why the spousal support should be that which the judge ruled, which is $1,000 a month for 3 years. That is important to my client, to have a cash flow, not in some retirement program that he will benefit from when he is 60 years old. Same thing with the attorney fees. As argued at the time that they were awarded, there have been substantial attorney fees in this particular matter. That is a current financial obligation that my client has. It makes sense that it not be offset, and the court did not do that. He set a time that the attorney fee should be paid within 90 days. I asked that be continued. All the other offset had to do with trying to justify the property issues in this particular matter, and they should be. Now, I don't believe that I missed the $12,000 figure. Go back and review that. I think I spent a lot of time just verifying numbers, and I'll give Mr. Toth credit. I think his numbers were on the money, but it took me about 3 hours to go back and review each of those numbers. I don't agree with his equalization chart. I don't think that was accurate. I suggest that my equalization chart is accurate in that regard. We did it different ways. In all due respect, I think mine is a simpler way to acknowledge what was. I took the assets, practical standpoint, his client is getting all the current money. in this particular matter. My client, only thing that he gets are assets that are in property form at the present time. And so I think it is important that that number be accurate in this regard. And I think mine is accurate in that regard. I will, at the argument of Mr. Toth, go back and review my numbers again, but I don't think that I missed that matter. In response to the other items, yes, I think they ought to be accurate based on your honor's ruling. In all due respect, I did object to the amount of income allocated to for child support. Your honor admitted that it was the 21 amount, which is inaccurate. The temporary order used the 158 figure and determination, and exhibit 47 of plaintiffs had the $24,000 bonus plus the other taxable amount, and the 158 I think was an accepted number in that regard. If that, I agree that your honor did not order that. If your honor is reflecting that, I put that in there so it'll be changed and be accurate now. Otherwise, once it's entered, I'll be back in front of the court saying, your honor, we made a palpable error in this regard, and here's the evidence that it should be made on. I am trying to get at least part of this finalized, and the 158 number is the accurate number that had been testified to by a number of exhibits and the various parties. That is why that is there. I did not change it in my proposed judgment because it is probably a reconsideration motion because your honor made a.
No, I picked the docket, and it's a year old plus, and it's from the archives. I think Loud, you should know this by now. I don't do any prep. Sometimes, but very rarely. So no, I didn't pick this case.
Ruling, although I don't believe it was consistent with the evidence. The personal property, in all due respect, there was a list of property that was stipulated to that each party got, and that was by agreement. And there are a lot of items on that going both ways. In all due respect, they haven't been all divided up yet. Your honor made a interim ruling about 3 items. That was your honor's ruling. That should be accurate in the judgment. There probably will be post-judgment motions to enforce, including the 25.
Yesterday we had a case where the lady, what did she say? Oh, that's right. She was dying, and the guy was mad that she was dying, or that she wasn't dead yet. That's what it was. That's what it was. We're all sort of confused. Let's let these rambling old men finish their ramble. The judge will bring it all together for us. I actually have complete faith. In fact, he's going to sum it up and rule quite quickly. And I guarantee the ruling would be the same if the judge, if they said, Your Honor, you've read the argument and we appreciate your time. In fact, that might even work better for them.
$5,000 worth of property, of snowmobiles and Rubicons and whatever else that are still in the possession of the plaintiff that should go to the defendant. But again, those are post-judgment matters. So the ruling of the court should be accurate. And that's why the Signa stock is important, that it be accurate what your honor ruled. It's important that the wizard or third app be accurate because that's what your honor ruled. And we need to deal with that. The fact that you argue, well, it's easier, I didn't get a counter. We haven't got the judgment in yet, and there's going to be some post-judgment things to deal with this. But the attorney fees and the spousal support are not property items, and I don't think they're subject to the offset. And I would respectfully suggest that the personal property, in my judgment, is consistent with what your honor ruled, and I would ask that the part of the order. Your Honor, I think we've all spent a lot of time trying to deal with the numbers in this particular matter. And I think as best as I have been able to cipher through review and your Honor's ruling, I am submitting that my judgment is appropriate judgment should be entered. I take exception that Mr. Toth is bringing up ancillary issues at this point in time. There's going to be a lot of post-judgment issues, and I ask that it not be ruled on today because there is important input in this particular matter, and there may be requests for additional things to take place based on the change in circumstance over this 9 months that we have tried this particular matter. Your Honor, those are my responses. I would respectfully indicate that my judgment is consistent with your Honor's rulings, and I would ask that be entered.
Okay, thank you. Well, what the court's going to do is the court does note, and Mr. Toth has referenced the record, which is helpful. The court did intend to, again, offset issues concerning property. I didn't intend to offset the issues concerning the attorney fees or spousal support, as the court had stated that, again, the attorney fees of $5,000 would be paid within 90 days of the finding. So, yes, I can understand the language, but it wasn't the intent that that would be offset or that the spousal support would be offset. The court would not offset those two particular matters. The personal property, that issue, the court had intended that would be the property that the parties had agreed upon at the prior hearing. I think that was the December 14, 2022 hearing that we went through the property, etc. I don't think there was a dispute on that, although there was a dispute as to what property that was going to the plaintiff, what the defendant had, and that was the intent for clarifying with some of those other items. But the court would, in fact, order that the items that the parties agreed to and put on the record at that December 14, 2022 hearing would be the property that would be exchanged. And if it's not, then again, the party would be responsible, the opposing party would be responsible for the value of the property not exchanged. That would include the title of the Raptor and the keys, which Mr. Toth had apparently included on his list. That's fine to put it on the list so that those get exchanged and provided to the plaintiff. As it relates to the communication app, I think the language as referenced by Mr. Toth is correct. It was Our Family Wizard or another one. If they could agree, if they can't agree, then it would be Our Family Wizard. I guess Mr. Schaefer will have to look back to see if the reimbursement of the $12,556 is included in those particular numbers that Mr. Toth has provided. If they're not, then it should be. But if it is, then you can basically do that. The court would likewise, as it relates to equalization, if in fact we're dealing with pre-tax and post-tax, the court does believe that there should be a reduction for equalization based upon tax rate. The court does believe that the 25% that Mr. Toth used is appropriate in this matter for reduction purposes, and the court would so order. Again, I don't know what that leaves us in the end as far as the total, and I don't know if the attorneys do at this particular point until it's recalculated and refigured, but I think that addresses all of the objections in this matter. And I would address the fact that on income, the court had used the plaintiff's 2021, as I stated, as I reviewed the records and stuff, that is all that I had. I didn't have any 2022, which the court would utilize again in the future in the event that that's brought forward and that's changed. But as of the time of my ruling, I was using the 2021. Mr. Toth, does that give you a better understanding as to what you need to do to recalculate all this and to prepare a revised judgment?
I do have, I would like a bit of clarification, Your Honor. What I can say immediately is that my calculation with the $16,094.11 included giving Mr. Klein credit for the attorney fee obligation. So that number is going to change with the court's ruling because so there's going to be a $5,000 change there. I understand the 25%. Your Honors, I understand the ruling in regard to the personal property. So let me reference my judgment.
I guess I know that some of you guys find this boring. I understand that, but to me, this is really interesting. We don't often hear lawyers disagree about a judgment. So that means all the evidence of this has been heard. The judge made his ruling, and the judge, we happen to know, is extremely clear and concise, and not concise. He's not concise. He's verbose. He is he speaks at length about the rulings that he makes, and he extrapolates a lot. And so I find it very difficult to believe that it's not a little bit contrived that they managed to not agree on the way that he ruled. You know what I'm saying? Like, it's interesting, but we've heard it time and time again. A judge will say, go ahead and write up that ruling, and if it's agreed to, then it doesn't need to come before me. And they always say, yeah, but you can bring it before me if there's any issues. It's very rare that we hear them come before the judge and say, hey, we have a problem here, we both disagree. It does happen from time to time, but I don't hear it very often in front of Kirkham. Neither of these lawyers are in front of him that much. We are in front of him a lot more than they are, I would bet. Which I will argue that the most important thing in terms of a legal defense is having somebody who understands the judge that you're in front of. Because every judge is so different that's the upper hand. That's the way you get in, is by finding somebody who knows how the judge works, when to shut the fuck up, when to reprimand you. And you're like, what the fuck? Believe me, like we've seen lawyers like whoop their clients, so to speak, in front of judges because they know that's what the judge is going to do. And it's much better coming from them, because what can the judge do? Reiterate what they just did? Not really. It's smart. Anyways, these lawyers are being dumb. But I do like to hear them disagree, and I'm intrigued that they're just listen to him speak and then they're going back to their thing. It's why I imagine a lot of judges have staff lawyers. Judge Manning comes to mind. She has a staff lawyer who drafts responses or drafts orders sometimes, because it is a lot to ask sometimes that one side drafts something completely fairly, because lawyers are, let's be realistic here, trained to look at all those nuances and be able to word things specifically. I mean, that's the game.
Well, the intent, Mr. Toth, as I stated, is back on the December 14th, when again you cross-examined the defendant about all of the items of personal property, but we had an agreement that we placed on the record as to those lists. Again, I wasn't gonna go through each and every item of personal property. The intent was, whatever the list was that we had, that they agreed upon, that would be the list of personal property that they would each get. And in fact, because your client had testified she didn't have various items, that the court ruled that those items would be turned over, or that in fact there would be a value ascribed to those, and he would be responsible for that. I tried to do the best I could based upon all of the testimony documents we had.
Your Honor, what we had in this case is we actually had an order that divided personal property, and that was entered months before the conclusion of the trial in this case. The list that I went through on the 14th were items from that court order that my client never received.
Okay.
So it wasn't necessarily limited to what stipulations were placed on the record on the 14th, because it basically governed the titled, other than the walk behind mower, it was all things that had been titled. So I just wanted to make it clear, as I understand, the judgment should include
it should include that order that we did, which was the list of those items.
and that's in there. In regard to, for example, we talk about the drone and the ratchet straps and gun safe with key and shop lights, et cetera. That should, if I understand what your ruling is that should not be included. It should simply be the items that you specifically identified. And then I should add a provision that says, in addition to anything that was placed on the record on the 14th. And I guess my question is there was no stipulation regarding placed on the record on the 14th regarding drones and handgun safe, et cetera. That had been memorialized by a previous order.
Right.
My concern
we'll go back to that order.
Okay,
my concern is to go to the order, which was the agreement on those two lists.
Got it.
With the exception of the testimony onto those other items.
Got it. Okay, I understand. And as I understand it, I can specifically include the title and the keys to the Raptor.
Correct.
And let me just, I only want to do this one more time. Your Honor, I had asked for some clarity regarding the implementation of your order, and that's not outside of anything. We have a problem. We have a problem with Mr. Klein playing games where my client gets a call. My client needs to know what the parenting time schedule is, and consistent with the practice in this county and every other county I practice in. If the court makes a ruling regarding parenting time, it should be respected from the time of the ruling. Because there could be that's simply my question. That's simply my question, Your Honor.
Okay, was the intent that ruling would take place? It would be effective the date I gave the ruling, notwithstanding. I mean, if you'd have had the judgment done in a day, it would have been in effect that day. If it took a month, again, the ruling would still be effective, but again, the court ruled on the parenting time, and that's what I expected the parenting time to be.
And that would be effective presently then, Your Honor?
Yes.
Thank you.
Effective presently.
Let me just see if there's any other.
According to my list, I think that takes care of everything, Mr.
All right, Your Honor, I will, I'll run some calculations and we'll resubmit a proposed judgment for Mr. Schaefer's consideration.
Okay.
Your Honor, I have some responses, please.
Okay, go ahead.
On the personal property, I believe Your Honor said that whatever's on the order that was stipulated to. And it was for both clients, that if they are not turned over, then the value would go through and it worked both ways.
I'm not going to utilize that one way and not the other way.
Okay, very good. So it's both ways that they are turned over the value. That correct?
Yes.
Okay, very good. And you made comment about the wizard and the third act. You said that you thought that Mr. Toast's language was accurate. I don't believe it is. He says it is the wizard. And
no, I meant when we were talking about he referenced
Just think about the record right now. It just is referencing wizards. There's no app. That makes me cry laughing because you and I know, but one day somebody reading that might not. It would. The wizard. What about the wizard? What about the wizard? So funny. I find that so funny. Also, you know, our family wizard needs to be careful legally about their copyright. Or sorry, their trademark becoming ubiquitous with the like sort of use of a parenting app, because like Band-Aid or a few other brands that are really close, like Xerox, you can lose a lot of your company's value. Parents must communicate via a wizard. Do we choose Harry Potter?
The ruling, and that would have been the correct determination on that. It would be our family wizard or a third app, whatever the parties could agree that, and if they can't, as I said, at that point, if they can't, then they can bring it back and we'll make a determination.
Okay, very good. Thanks for that clarification.
Okay. Thank you, gentlemen. We'll end at 10:15 a.m. You're free to go. Have a good day.
Thank you.
Oh, Lisa, be careful what you wish for. We're coming up on a new case.
The 9:30 because we have an interpreter.
We have a what?
An interpreter.
Oh, okay. Okay.
Lisa!
Go ahead. We'll do that.
Lisa, you spoke that into existence. Do you know how rare it is to have a fucking interpreter case in this fucking court? I'm blaming you entirely for that. Entirely.
It's on Calderon
Yep.
versus Calderon.
Check off ceiling fan on your bingo cards, ladies and gentlemen. Zoom ceiling fan off your bingo cards. Plus, it looks like we have a vampire appearing here.
Can you please unmute? Yes, unmute interpreter.
Okay, I'm here.
All right, perfect.
That's the interpreter? If you had fucking asked me to pick the person on this screen that was the interpreter. Oh, Lord. Oh, Jesus. Oh, Jesus. You literally cannot write it. You fucking cannot write it. Ma'am, why don't you know how to use the phone properly? Why is your ceiling fan visible? What angle is your computer?
Please unmute. Anya, is your client the one that is in need of the interpreter?
No, it is Miss Moss's client.
That's correct.
Your Honor, he's in my office. I'm gonna run over real quick and get him up to him. Oh, there okay, sorry. Thank you. Nope, they're good.
Calling
All right.
case
Whoa. Shut up before you use your really annoying voice. We're gonna go ahead and try and guess what language they're interpreting. I'm guessing Spanish boringly. But you can get your guess right now. We it's we normally skip them. We normally don't, to be frank with you. Uh, uh sign language interpreters that were sort of cool. Right here.
Arcelia Calderon versus Antonio Calderon.
Llamando el caso 2023-159 Arcilia Calderón contra Antonio Calderón.
What's involved, before we start, we'll have the interpreter sworn in, and we'll proceed.
Do you
In her really annoying voice. Do you swear to interpret from this language into English into this language?
swear or affirm that you will truly and accurately interpret these proceedings between the courts, counsel, parties, and witnesses in the matter now pending to the best of your ability?
I do.
Bitch, from what language?
Court will note the appearance.
Do you not think that it would be important to explain what language it is for the record? C. Ed says.
Of Ms. Moss on behalf of the plaintiff, Ms. Henderson on behalf of the defendant.
La Corte menciona a los abogados de la parte acusada y a la parte acusadora.
This matter is before the court on the defendant's motion for temporary custody and parenting time.
Esto tiene que ver con una custodia temporal de tiempo de los padres.
Okay. Court does note, as I reviewed the file, that there is an issue as it relates to the paternity as well of one of the children.
Miré los documentos y hay una duda en cuanto a la paternidad sobre uno de los niños.
Court will, on that issue, is order that the parties would submit to a DNA testing with the child and with them respectively.
La Corte dice que tiene que hacer examen de DNA tanto los padres como el niño o niña.
The parties will pay 1/2 the cost of that testing, subject to later reapportionment.
Ok, cada padre pagará la mitad del costo de esos exámenes, teniendo en cuenta que en el futuro puede haber una devolución del dinero.
Now, Ms. Henderson, you can proceed on your motion.
Thank you, Your Honor. Wanted to address also that the court has a scheduling conference at 1:15 today. Is that something the court wants to address this morning as well, or no?
I will not address that this morning. We're so far behind on motions now. I don't have time for that.
Thank you, Your Honor. And then as to the DNA testing, does the court prefer any specific facility or just any accredited
No.
facility as agreed?
But you can get an agreement and use that facility.
Okay, thank you.
Pueden usar cualquier lugar para el examen de DNA.
Thank you. May I proceed, Your Honor?
Yes, go ahead.
Thank you. Your Honor, the parties have separated a long time ago, over 2.5 years ago. And since that time, my client has been an active participant in the children's lives.
Ok, la pareja se separó hace más de 2 años y medio. Desde ese momento, mi cliente ha sido una parte activa en la vida de los niños.
Thank you. The children are relatively young, and the parties have actively participated both in the raising of these children. The children are currently 5 and 3.
Los niños tienen 5 y 3 años, son relativamente jóvenes. Ambos padres han participado activamente en criarlos.
Thank you. And Your Honor, my client is seeking joint legal and joint physical custody of the minor children.
Y mi cliente está buscando una custodia legal y física conjunta.
With the parenting time of a week on, week off type variety.
Con un tipo de caso en que el padre
A week on, week off type variety. I prefer more on than off. Thank you, Mikey. You're so sweet. The only problem is that oh, there we go. My boobs can be above the donos. Thanks so much. You're so sweet. Super duper sticker. I know. And also, I think that the interpreter must be behind a lot. But reminder, this is old, so they've caught up by now. They figured it out.
Lo tiene una semana y la madre lo tiene otra semana.
It should be noted for the court that since approximately December until last week, my client has been blocked on plaintiff's phone and plaintiff was refusing him parenting time.
Es de notar que desde final de diciembre hasta hace una semana o así, el demandado tenía.
El demandano. I don't even know what that means, Mikey, but thank you so much. I know you're always on. You're working, you work harder than almost anybody I know in the whole entire world. Thank you so much. Seriously, as always, thank you for your support here, but thank you very much for your support always. I appreciate it. Yeah. Mom is playing games, right?
Ha bloqueado el teléfono para hablar sobre los tiempos de parentaje.
Only upon Ms. Moss's involvement, my client was able to get one weekend parenting time, which occurred past weekend, and it went really well.
Solo por la intervención de la señora Moses, mi cliente pudo tener un fin de semana con los niños hace como una semana y le fue muy bien.
My client works at Denso. He works second shift. However, he has a sister that is able and willing to provide care for the children when he's at work.
Mi cliente trabaja en Denso en el segundo turno, pero tiene una hermana que está dispuesta a cuidar a los niños mientras él está trabajando.
His regular parenting time schedule is from 11 p.m. until 7 a.m. So he would be able to spend time with the children both after school and in the morning to get them ready for school.
Su horario es de las 11 de la noche a las 7 de la mañana, lo que le permitiría estar con los niños antes de ir a la escuela y después de ir a la escuela.
Up until December, the plaintiff also worked at Denso and also third or second shift. So the parties essentially had very similar incomes and very similar work schedules.
Hasta diciembre, la demandante también trabajaba en Denso en el segundo o tercer turno, así que tienen más o menos el mismo horario y el mismo salario, más o menos.
It is my client's position that in preparation for filing for divorce, plaintiff got fired from the Denso job and has been staying home doing odd jobs from the house with the children after filing for divorce.
Durante los procesos de divorcio, la demandante fue echada de Denso de su trabajo y ha permanecido en la casa con los niños mientras este proceso de divorcio continúa.
However, it is my client's understanding that plaintiff is seeking for factory type work. So essentially, the parties may be in the same position again, where both of them are working in a factory type schedule.
Mi cliente tiene entendido que ella está buscando otro trabajo en una fábrica, entonces podemos asumir que en el futuro los horarios de ambos van a ser similares.
Your Honor, we are asking for the parties to share joint physical custody as my client is able and willing to provide care for the children and has provided care on a regular basis, essentially exercising equal or close to equal parenting time since the separation in 2019 up until December of 2022 when plaintiff refused him parenting time.
Desde 2019 hasta diciembre del año pasado, mi cliente proveyó por los niños y estamos pidiendo una custodia física conjunta igual y él ha proveído por ellos desde que se separaron.
we're asking if any child support is to be ordered, that Ms. Calderon be imputed at her previous income at Denso, which essentially is income very similar to my client's, and otherwise that child support be ordered in accordance with the formula.
Solicito que si hay que mirarlo el mantenimiento de los niños a nivel monetario, se tenga en cuenta el dinero que ganaba la demandante antes de ser despedida de Denso, ya que los valores son similares.
My client is stating that the joint physical custody and joint legal custody with equal or close to equal parenting time would be in the best interest of the minor children.
Mi cliente dice que la custodia legal y física conjunta sería lo mejor para el bienestar de los niños. Y antes se me olvidó decir que para lo del dinero de manutención se puede usar una fórmula. Sorry, I forgot something before and I'm just interpreting it.
Your Honor, we're asking that the children have equal access to both parents and that plaintiff stop refusing my client parenting time and that my client has ample opportunity to make up for the lost time. Both parties reside in the same school district.
Pedimos que ambas partes tengan acceso igual a los niños y tiempo de parentaje que sea lo mismo y que la demandante no le quite tiempo de parentaje al papá. Y ambos padres viven en el mismo distrito escolar.
Ms. Moss, what's your response?
Thank you, Your Honor. First of all, this is not a recent separation. The parties have been separated for over 3 years.
Esta no es una separación nueva. Los padres han estado separados por más de 3 años.
And for that entire time, my client, the plaintiff, has had the established custodial environment.
Y durante todo ese tiempo, mi cliente ha tenido que establecer una atmósfera de custodia.
She has been the sole provider financially and in terms of care for the children. She's taken them to every appointment. She puts them to bed at night. She gets them dressed. She provides all clothing, all food without support from the defendant.
Durante todo ese tiempo, ella ha sido financieramente responsable por los niños. Ella los ha llevado a cada cita, los acuesta de noche, los viste y ha tomado todo el cuidado de ellos en sus manos, mientras la otra parte no ha hecho nada.
The children are accustomed to looking to her for support, and that is the status quo and has been for over 3 years.
Los niños están acostumbrados a mirarla a ella para apoyo y así ha sido por más de 3 años.
And that includes when she worked the same schedule as the defendant until December, when she was unable to maintain that employment due to mandatory overtime, and her mother, who helped her with childcare, started her own job.
We did see that one time, Vince, as I think about it. Good night, Bev. The one that comes to mind is, in fact, when a judge was interpreting for the court, but like got halfway through and was like, actually, never mind. I don't think I can do this. It was really odd. That's also, I've had them bring in the wrong language interpreters quite a bit. But Spanish has been pretty solid. We've had some that are really good and you can tell, and then some that are really not good and you can tell, but a lot of it has to be like based on how the court sort of manages it. And I don't think that they actually transcribe it into the record in Spanish. I don't believe that's included in the services. What I think happens is they just say other language or like Spanish. I'm being serious. Like, it's just not, you can't expect the court clerk to have to know another language or every language that an interpreter comes in and deals in. So, you know, bye, Peter. Bye. Let's finish this off. As always, it takes me back to when I failed Spanish. Yes, I failed Spanish. I failed sewing. I failed everything. We've learned now that I have a different brain, so that's why I fail all the classes. Duh.
Y eso fue así hasta diciembre, hasta donde cuando ella no pudo mantener el trabajo debido a que el sobretiempo, el tiempo extra era obligatorio y también con problemas con su madre.
Currently, my client works in her home after the children are in bed so she can complete all parenting duties.
Sorry, can you repeat the first part?
Yeah, can you repeat that again? What does she do in her home after the children go to bed so that she can complete her parenting duties? Tell me. What was it?
Currently, my client works in the home after the children are sleeping so she can parent them.
Okay, en este momento ella trabaja en la casa después de que los niños se van a dormir.
However, plaintiff is very willing to agree to defendant having substantially more parenting time than he's exercised in the past.
Sin embargo, ella está dispuesta a darle a la otra parte más que suficiente tiempo de lo que ha tenido para tiempo de parentaje.
At this point, she has suggested every other weekend from Friday at 6 to Sunday at 6, and once a week on Wednesdays for a 2-hour period that the parties agree to.
En este momento está sugiriendo cada otra semana de viernes desde las 6 de la tarde hasta el domingo a las 6 de la tarde y los miércoles 2 horas.
It's important to note that my client offered defendant parenting time frequently and he declined it.
Es importante decir que ella le ofreció a la otra parte tiempo para que estuviera con los niños y él declinó esa oferta.
Defendant's proposed parenting time is very disruptive to the children and the status quo.
El tiempo propuesto, la manera propuesta por la otra parte es muy irregular para los niños y va en contra del statu quo.
Despite offers from my client, he has not had the children for an overnight since the separation.
Desde la separación y aun cuando mi cliente le pidió, él no ha tenido los niños por la noche ni una sola vez.
My client estimates that he would typically see the children once a week for about 2 hours at a time.
Ella estima que él mira a los niños, está con los niños 2 horas a la semana.
This proposed schedule is further disruptive as it requires the children to go to defendant's sister's home for the overnights, where she has, I understand, 3 children of her own, even though plaintiff is available.
Esto aún es peor porque los 3 niños, los niños tendrían que ir a la casa de la hermana donde creo que hay 3 niños y eso sería muy difícil para ellos.
Plaintiff has absolutely not withheld the children from defendant.
Definitivamente, la demandante no ha retenido a los niños o las visitas de los niños del demandado.
There was an issue that she had a second phone and requested defendant to use the new phone number, but he did not.
Hubo un problema porque ella tenía un segundo teléfono y le pidió al demandado que usara ese número de teléfono y él no lo hizo.
Over the separation, defendant has not answered plaintiff's text offering parenting time, but he has answered texts about their truck.
¿Their truck? Ok, durante
like a
ese
vehicle.
tiempo, él no ha respondido a los mensajes de texto que tienen que ver con los niños, pero sí con los que tienen que ver con una camioneta o carro.
So plaintiff has been solely responsible for the care of the children since the separation. And defendant has not been involved in a predictable or consistent way.
La demandante ha sido responsable de los niños desde que se separaron y el demandado no ha sido, no ha ayudado para nada en una manera consistente.
We are asking to preserve to some degree the status quo, but also increase defendant's parenting time to every other weekend and 1 weeknight for 2 hours.
Estamos pidiendo que se mantengan más o menos las cosas como están, pero incrementar la presencia del demandado cada otra semana y una vez a la semana.
This gives defendant parenting time when he can actually interact with the children rather than leaving them with his sister.
Esto le da tiempo al demandado de tener tiempo con los niños realmente y no dejarlos con la hermana.
We agree to comply with child support based on the child support formula, but would like my client's current income used.
Estamos de acuerdo en que se utilice la la fórmula para lo que se trata de manutención financiera debido a las circunstancias de mi cliente.
And we agree that the minor child needs to be excluded from the marriage.
Y también estamos de acuerdo que el menor de los niños debe ser excluido del matrimonio.
And we agree with joint legal, joint physical custody.
Y también estamos de acuerdo con la custodia física y legal conjunta.
Thank you.
Ms. Moss, the last statement you said we agree to joint legal and joint physical custody. Is that correct?
With the parenting time as we suggested, correct?
Okay.
Pregunta si dijo que una custodia legal y física conjunta, y ella dice que sí, teniendo en cuenta el horario que ella ya presentó.
Ms. Moss, just to clarify, you said that the defendant did not have any overnights since the separation back in August of 2019. Is that accurate?
That's my understanding, yes.
Okay.
Para clarificar, el demandado no ha pasado ninguna noche con los niños desde que se separaron en el 2019. Su abogada dice cierto. Eso es lo que entiendo.
Ms.
Your Honor, may I please
Henderson, is
respond?
that what you believe to be accurate, that your client had no overnight since the separation?
That is absolutely not accurate, Your Honor. My client exercised on average 3 to 4 overnights per week, which is why I said that their parenting time has been equal or close to equal. They didn't have a set schedule. They both worked the same shift. And up until the end of December of last year, during plaintiff's work hours, her mother provided care.
Please let the interpreter.
Oh, I'm sorry, Your
Going
Honor.
a little long there.
I apologize. If you need me to repeat, I will. I apologize.
Okay, wait. Desde hasta diciembre, no es cierto, hasta diciembre él pasó de 3 a 4 noches a la semana con los niños. Can you repeat the last part?
Sure. And up until December of 2022, when plaintiff quit or got terminated from her job, her mother provided care during the night when both parties were working. So that situation, that status quo continued up until about 2 months ago.
Hasta diciembre del 22, la madre de ella los ayudó mientras ellos trabajaban para cuidar a los niños de noche.
Well, what the court's going to do in this particular matter. Go ahead, interpreter.
Lo que la corte va a hacer en este asunto
As I am going to, pursuant to the agreement and the understanding of the parties, is grant to them joint legal and joint physical custody.
les voy a dar una custodia conjunta legal y física.
And the defendant's parenting time will be on weekends from Friday at 6 o'clock p.m. to Monday morning at 9 o'clock a.m.
Y los tiempos de every other week, Your Honor.
No, every week.
Ok, y todas las semanas los niños estarán con el demandado desde las 6 de la tarde del viernes hasta las 9 de la mañana del lunes.
And Wednesday for a 4-hour period to be agreed upon between the parties.
Y los miércoles por un periodo de 4 horas que las partes deben ponerse de acuerdo.
Court will also order standard alternating holidays, spring break, summer break, etc.
También se ordenará una presencia alterna cuando haya las vacaciones de primavera, las de verano, etc.
Court will set, again, support consistent with the income of the parties when the plaintiff was employed at Denso, subject to later modification based upon testimony at a subsequent hearing.
La Corte pone el apoyo financiero teniendo en cuenta lo que ganaba la demandante cuando estaba trabajando en Denso, y esto variará cuando ella tenga otro trabajo.
Anything else, Ms. Henderson?
¿Algo más?
Okay, Ms. Moss?
Your Honor, I'm sorry, I didn't answer the question yet. I paused for the interpreter.
Sorry.
I didn't, Ms. Henderson?
So my only question, Your Honor, with spring break coming up in a week or so, could my client please be granted that in this year since he missed so much parenting time due to?
We could do that. We'll grant him spring
Thank
break
you.
this year and then alternate thereafter.
Ok, puede mi cliente tener los niños durante el receso de primavera, ya que este es el primero y el juez le otorga ese derecho, entonces este año él tendrá a los niños durante el receso de primavera, que debe ser en unas semanas o una semana.
Ms. Moss, anything else?
No, Your Honor.
Okay, thank you. I'll ask Ms. Henderson that you would prepare that order and submit under 7-day notice.
Thank you. Your Honor, for the child support, should I make it effective upon entry?
That would be fine.
Okay, thank you very much.
Court will end this matter at 10:38 a.m. You're free to go. Have a good day.
Todo el mundo puede irse, nos cerramos a las 10:38 de la mañana, que tengan un buen día. Good day to everybody.
Thank you.
Thank you.
Thank you.
Anya, if you want to stay on, I will.
Yes, I figured you would want me to, yeah.
Next case, which is Defy,
Chappelle?
Chappelle versus Depew.
And he did giving him spring break, right? But there was such a disparity between what they believed. One of them was like he never had any overnights, and the other one said he had overnights 3 to 4 days a week. That's huge difference. Night Loud. Also, they just glossed over the fact that they bastardized one of the children of that marriage. Like, oh, don't forget that we don't give a fuck about little Albert.
Mr. Defy? Chappelle versus Christopher Defy. Today is Monday, March 13th, 2023 at 10:40 a.m.
Court will note the appearance of Ms.
What is
Henderson. on behalf-
happening? What incarnation? Who's connected via a wind tunnel and a Nokia phone?
behalf of the plaintiff, Ms. Huffman, on behalf of defendant. This matter is before the court on the defendant's motion to show cause. I have reviewed the motion. I've also reviewed Ms. Anderson's answer. Is there anything else that you want to add, Ms. Huffman?
Not anything else specific. I just wanted to do a quick summary if I might, if the court needs it. Otherwise, I won't, but
Okay, now if there's something you want to point out in summary, go ahead. I just don't need to hear the motion again.
Okay, so basically what I wanted to point out is that this 2 weekends in a row that this minor child has been trying to have parenting time. It's not like dad is preventing this. Dad is taking this child, but mom is refusing to allow the child to bring his phone, which this court has already ordered that he be allowed to bring his phone. So it is extremely detrimental to this child's well-being. We already have the one child refusing to go. And like I said, dad keeps talking this child into going, even though he's afraid to go. And his mom states in an email that she's afraid of the child as well. So I don't know what we're doing here, forcing this toxic situation to continue. It has to stop. It should not even be a question at this point. So we're asking the court to suspend parenting time at this time, or to order supervised parenting time with the maternal grandfather. Oh, sorry. And we would also ask for attorney's fees in this matter. I know we didn't specifically ask for it, but we did ask for any other relief the court deemed appropriate in the matter. And in that case, we would ask for $620 for the filing fee and the amount of time it took to do the motion.
Okay. Ms. Henderson, what's your response without reiterating your answer?
Thank you, Your Honor. In this matter, the court has ruled that the minor children are to have access to their mobile phones in the respective parents' home. My client has a separate phone to use for the minor children in her care. They each have a phone in her care. The court previously has ordered that the parties are to engage in co-parenting counseling with Dr. Haugen. My client has participated at this point in at least 3 sessions. The recommendation of Matt Bosher, to whom Dr. Haugen referred the counseling to, is that each party keep their phones at their homes, that the children have phones to use in their homes, but they don't take them back and forth to prevent the disputes about that, Your Honor. So she is following that recommendation. She informed Mr. Depew about that recommendation. We are unsure if he actually engaged in any sessions at this point, but my client has followed through with the order and has actively engaged in counseling. There is absolutely no evidence that parenting time is harmful for the children. And that is the standard that the court has to use when considering suspension of parenting time. We're dealing with a defiant teenager, or 2 teenagers at this point, Your Honor. Co-parenting counseling has been requested and ordered. My client is following through with that. So that is an issue that needs to be brought up and worked through the counseling rather than getting the court involved endlessly in this matter. One point that is asked for in the motion at this juncture is that Cameron is included in the counseling. It has been done, even though Mr. Depew did not specifically ask my client permission to enroll him in counseling, but the child is attending counseling, and my client is in touch with a counselor regarding the children's counseling at this time, Your Honor. Further, I want to point out that this motion is verbatim, a motion that has been denied a week prior with a different title. And that week prior, the motion was filed as ex parte motion to suspend parenting time.
That's interesting because, as we know, there is a legal concept about 2 bites at the apple, where you're not allowed 2 bites at the apple. And so if she's correct that it's, unless the ex parte motion was denied pending a hearing, and then this is that fucking hearing, and then that would be disingenuous representation on the lawyer's behalf. But like you and I know, because we watch a lot of court, that an ex parte TPO, for example, means very little compared to a full TPO that's gone through a full hearing. Ex parte things are done in emergency situations because things have to happen quickly, but they're subject to change very quickly, and they are without scrutiny of the other side. That's what it means, ex parte, without the other party. So it's interesting to me. Now, if the motion was denied outright, then it would be sort of not cool to file it again with just a different title, I think.
Your Honor, Mr. Depew is trying to cause my client further emotional distress, further disparage her in front of the minor children, and cause her additional attorney's fees, which we're requesting in the amount of $700 at this point. Further, Your Honor, we have included some reports that refute the statement that my client is abusive to the children or that she is not following the court order. That is simply not true. So at this point, Your Honor, we're asking for the motion to be denied in its entirety due to no harm caused to the children or no showing of that harm caused to the children. My client is following the co-parenting counselor's recommendations as she was ordered to by the court. And Your Honor, we're asking for attorney's fees to be granted due to continuous filings of the motions in court, even though this matter is currently being addressed by the co-parenting counselor, as was requested by the defendant previously, Your Honor. Thank you.
Okay. What the court's going to do is the court is going to order that the children and that would include Cameron as well, would continue in, with the present counseling. That, the court would order that the children be allowed to maintain their phones while in the parent care of either of the parents. So if they want to take whatever phone they have from the one parent to the other, they have a right to do that. We'll put in that there was some issue brought up about the contact between the parents. The court will state that each parent is limited to one text or one call per day with the children, and the court will reserve on all further relief pending an evidentiary hearing in this matter, which will not be set until such time as we have some counseling and other report and recommendation from the counselor. So, Ms. Huffman, you can prepare that order and submit it under 7-day notice. Court will end this matter at 10:47 a.m. You're free to go. Have a good day.
Thank you, you too.
Your Honor, just to clarify, the court is not making any determination on parenting time, suspension, or change.
I am not.
Thank you.
When that comes up, is it them clicking off?
No, I'm helping to click them off. I'm gonna check in some people, Judge, just because I wanna make sure they're.
We'll see.
You know, that they're behind.
Okay.
All right. iPhone, can you hear me?
Samsung nods emphatically. iPhone, can you hear
Can you
me?
hear me, Sarah?
Oh, yes, I can hear you.
Okay, formally, were you formally Sarah Jones?
Correct.
All right, just letting you know, we're running behind. I'm gonna place you in the waiting room, not disconnect.
Okay,
I will, bring you in as soon as I can, okay?
sure, sounds good. Thank you. Uh-huh.
Justin, please unmute. Please unmute. Good morning. Your first and last name, please.
You're mute. He's muted.
Justin, can you please unmute?
I got unmute now.
All right, perfect. Your last name, please.
Jones?
Perfect. I'm gonna place you in the waiting room. We are running behind. I will get to you as soon as we can, okay? Do not disconnect.
Okay, thank you.
Oh, she's like that
Please
work
unmute.
receptionist.
Samsung, first and last name, please.
Dramion Coleman.
iPhone replies.
Here.
This is comical. If it wasn't
Okay,
so
Dramion, I'm placing you in the waiting room. Do not disconnect. We are running behind. I will get to you as soon as I'm able, okay?
Okay.
Thank you. Samsung, first and last name, please. Can you hear me?
Me?
Yes,
My name is Betty Hunter.
Betty Hunter. Okay,
My
Betty,
name
just
is
letting you know, we are running, oops, sorry, spelled your name wrong. We are running behind. I'm
Bitch,
gonna
we
place
all
you in the
heard
waiting
you.
room, and we will get to you as soon as we're able to, okay?
All right, thank you.
Thank you. Okay.
Doesn't Zoom have a waiting room just for this?
Kelly Pelosi, Adams.
Okay.
Adams. I do not have defendant present.
Oh, who's
This
that?
person is attempting to connect. Please connect to audio.
Oh, ma'am, you make people not want to connect to audio.
I'm trying to get someone to connect. All right, I guess I'm just gonna. call
Someone
this.
is at a bird
Oh,
zone.
right here.
Bird zone. What the fuck is that, Paisley? Come on.
Please unmute. Your first and last name, please. Your name, please.
Lisa Johnson.
Yep, I have you, Lisa, on this iPhone. iPhone, first and last name.
Oh, Justin Burton.
Justin Burton.
And my birds.
Okay,
Justin Burton and my birds.
Justin. What
Or is
time
it
was your
Lisa
hearing?
and her birds?
9 o'clock.
All right,
9
then, yep, I'm gonna put you in the waiting room. We'll get to your case next case, okay?
Okay, thank you.
Thank you. Calling case 2019-101 DM Lisa Adams versus Stephen Adams. Today is Monday, March 13th, 2023 at 10:51 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for modification of custody and support. The defendant has not appeared. It was set for 9 o'clock. It is now 10:52 a.m. Court will find based.
I will find that they just check somebody else in for their 9. No, you better check that, Judge.
Upon the petition that there's sufficient proper cause change of circumstances to meet the threshold of ABARCA for an evidentiary hearing, the court will refer the matter to the referee for an evidentiary hearing. Is there anything else, Ms. Podolsky, that you need?
Nothing for today's purposes. Thank you.
Okay, we will do that order, and we'll end this at 10:52 a.m. You're free to go. Have a good day.
Thank you.
I can't find anything on Burton. I saw it earlier.
Yes, it's.
Oh, there it is. I see it.
All right. I think you're all set for the day, correct, Kelly?
I've got the 10:30.
Oh, okay, I'll put you in the waiting room.
Yeah,
Still
okay.
on our 9s. All right.
That bird was so loud. Can you imagine living with that all the time?
We have Jennifer Reed.
Oh, you have somebody.
Yes, Jennifer is appearing before Attorney Umlaw
Oh,
because he had attended Church Johnson.
okay.
Okay, calling case 2020-1409 DS, Nicole Cornely versus Justin Burton. Today is Monday, March 13th, 2023 at 10:53 a.m.
Court will note the appearance of Ms. Reed in place of Mr. Umlauf in this matter. The matter is before the court on the defendant's motion for temporary suspension of parenting time. Ms. Reed.
Thank you. In respect for the court's time, I'm going to largely rely on our pleadings, but my client has serious concerns that plaintiff exercising any parenting time poses an imminent threat to the health and safety of the children in this matter. She has a serious history of drug use, which was current up until my client last saw her, which is on around January 22nd of this year, when she was found beaten and appearing to be under the use and influence of heroin. She's currently in a violent relationship with a gentleman who has perpetrated violence against the plaintiff in front of the children and also chased the plaintiff in a vehicle. We believe these issues with the drugs and the violence are continuing, that she does not have a stable home or environment for the children. The children aren't attending school while they're in her care, and so we're requesting that her parenting time be suspended until the evidentiary hearing on April 25th.
Okay. Ms. Cornely, what's your response?
It's all lies. I mean, the school, the week that he accused me of, the 16th through I believe it was the 23rd, my oldest daughter had strep and Madison has stomach issues, which Justin has actually kept her out of school for multiple days since she's been with him, and he's been withholding my parenting time. I've turned in a motion of him denying my parenting time. I filed that, I believe, 2 weeks ago. He has held her from me since the end of January. I live by myself with my kids. I was in a relationship. It was not good, but the kids were not involved. I am not with him any longer. It's just me. I have a full-time job. I'm not on drugs. I will subject to a full drug screening.
Okay. Anything
And-
else, Ms. Reed?
Yes, Your Honor. It's my understanding that the plaintiff hasn't done anything to exercise her parenting time since the 22nd of January. She has called approximately twice for 1 minute each phone call to talk to the children. She has not requested her parenting time, and it's my understanding that she also has an active bench warrant out for failure to pay child support.
Okay. Well, what the court's gonna do is at this point, we have again, an evidentiary hearing coming up in April. The defendant has stated, excuse me, the plaintiff has stated that she lives by herself, that she's not in that relation.
No, she stated that there are children there and there's a child there. I can hear a child. Uh, uh,
Relationship, which apparently has caused the issues and contention, et cetera. The court is going to deny the motion at this time. And the court would order that her parenting time would resume. I don't know if that's Wednesday or Friday this week, but
It would be Sunday.
what?
It would be Sunday. It's Sunday to Sunday for us.
Okay. The court would order that that would resume then on Sunday and would continue until there's such time as we can have an evidentiary hearing. So that will be the order of the court. I'll ask Ms. Reed if you'd prepare that order and submit that under 7 day.
Yes, Your Honor.
Court will end this matter at 10:57 a.m. You're free to go. Have a good day.
Thank you.
I think that says something about the attorney. No offense, allegedly, obviously, in my opinion, but judge can't think much of her opinion. Wow.
All right, the next case is Dawn Food Products versus Rock and Roll Donuts.
Like those are serious allegations. He discounted them entirely.
Plaintiff or defendant is not present. Defendant, Sandra Bartlett.
There is a defendant?
There is not.
Okay.
Defendant is not present.
Okay. Yeah, we do. You can delete the other one.
Can you hear me, Mr. Buttenberg?
I can. Can you hear me?
Yes.
Yes. Calling case 2022-3307 CB Dawn Food Products versus Rock and Roll Donuts and Sandra Bartlett. Today is Monday, March 13th, 2023 at 10:58 a.m.
Good morning, Mr. Brottenberg. Sorry to keep you waiting. We've had a tremendous amount of motions today and we're just working through them as we can.
I understand, Your Honor. No problem.
Court will note that it is now at 10:58 a.m. The matter is set for 9:30 a.m. No one has appeared on behalf of the defendants. As a result, the court will enter your default judgment as submitted in this particular matter. And that should conclude the matter. Is that correct, Mr. Bottenberg?
That is fine. You are correct, Your Honor. It's good
Okay.
to see you again.
We'll get that entered and get that out to you. So we'll end at 10:59 a.m. You have a good day.
Thank you. Same to you, Your Honor. Take care.
The big default judgment. Look at that. Be patient. And that guy billed for that whole hour. You know that, right? While he sat on Zoom.
Okay.
You need to find out who Niels Magnus is appearing on. Bring him in as well. Niels, please unmute. Just checking to see which hearing you plan on appearing on this morning.
The hearing I'm appearing on is Coleman and Samuel.
Right, I'll put you in the waiting room. I'll call that case next.
Thank you.
Where is Justin? He was here. Justin is joining. Can you hear me, Justin?
Yes, I can.
Okay, calling case 2015-943 DM, Justin Jones versus Sarah Jones. Today is Monday, March 13th, 2023 at 11 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This is before the court on the plaintiff's motion to set aside referee. Or set aside, is this the default or the referee recommendation? Mr. Jones, just so you know, as Ms. Podolsky has pointed out in her answer under Court Rule 3.215, that your motion has to contain a clear and concise statement as to any error that the referee made. You can't simply set aside the referee recommendation because you don't like it. You have to have some legal or factual basis. What is your legal or factual basis for seeking this to set aside the referee recommendation?
Well, there's a decision last year from February that it was just based on my residency. And then I come in with residency thinking that I could have my joint custody back. And then here now I'm being told that 1 month that a residency isn't good enough to have my joint custody back. So, I mean, I'm under your lease. I've had my employment for 6 years. There's no reason why I shouldn't end up having my joint custody back.
Okay. Ms. Podolsky.
Thank you, Your Honor. There was a motion last year to modify custody, parenting time, and support. There was a full evidentiary hearing held. This decision was not based solely on the plaintiff's residency. It was a major factor, yes, but it was not the sole basis of that decision. The referee made a decision at this time that became the new order of the court. His current motion simply stated that he has a residence now and should have joint custody again. The referee agreed that that did not meet the standard as set in Vodbarka to change custody and parenting time. And now again, as the court has stated, this current objection, this motion to set aside the referee recommendation does not comply with court rule. It does not state a clear and concise statement of specific finding or application of law that the referee made that was an error. So we are asking the court to deny this motion and uphold the referee decision and continue the current orders of the court.
Okay, Mr. Jones, any response?
So, like, he was basically saying that 1 month isn't stable enough, but that's not written into law what is defined as stable enough. You know, I've been through this, the kids' life as a stable father. I've been here. I've been through athletics, traveling. I do my parenting time, Thursday dinners. Boys are no longer really children. They're adolescent young men. They need to be respected as where they would like to be, when they would like to be. They want to be back home with dad. You know, I get a home, like, here's a bedroom, brand new beds. Over at Sarah's house, they sleep in a basement. Torrin is sleeping in a closet in a bedroom without egress, without fresh air, like no windows, sleeps in a closet. But here, yeah, I get a stable home, and then where in the laws are written that there's a time period. Like, all I know is based on my residency. The time I had no residency last year, now I have residency.
Okay. Well, what happens in this case, as you probably know, as the referee would have went over under MCL 722.23, there are 12 factors the court looks at to determine, again, custody in this particular matter. Again, the stable, satisfactory environment is just one of those particular factors. And you have not, when the referee, again, utilized that and said, well, that 1 month was not sufficient, the court cannot see any error on that particular factor based upon what you've presented in this particular case. There may be other factors. Again, stable, satisfactory environment is one factor, not is one of the 12. And as a result, the court is not able to find error on the part of the referee based upon your maintaining residence of for 1 month at the time of that particular hearing. Not to say that it couldn't, but again, that is only one factor under the again, Child Custody Act. And as a result, the court does not find any error by the referee. So the court will in fact deny the motion to set aside the referee recommendation at this particular time. And that will be the order of the court. We'll end this hearing at 11:05 a.m. You're free to go. Have a good day.
Thank you.
Yikes. Oh, is that the courtroom? It's so depressing.
Damian Coleman versus Killian Samuel. Killian is not present.
Oh my God. Look, the wizard. It's the wizard we were talking about.
Samuel just got moved to a different jail. The jail is not aware that he had a court hearing.
Calling case 2022-2045 DP, Damian Coleman versus Kylan Samuel. Today is Monday, March 13th, 2023 at 11:06 a.m.
Court will note the appearance of Mr. Magnuson in this matter on behalf of the front of the court. The matter is before the court on the plaintiff's motion to set aside referee recommendation. It basically states, Ms. Coleman, that again, you had some issue with regard to, or Mr. Coleman, you had some issue with regard to, again, the DNA and all of that. Is that correct?
Yes, yes, Your Honor.
Mr. Magnuson, what's your position on this?
Well, Your Honor, what we could do, our office can facilitate genetic testing. This is an action under the Paternity Act. I would simply suggest that the order remain in place. It is a zero order, taking into account the defendant's incarceration status. And I believe that we could accomplish the genetic testing and take care of that issue while the order remains in place. And if there is an exclusion, we can deal with that down the road.
Okay. Plaintiff, is that something that's agreeable?
Yes, I would just like a genetic test of me and Kylan Samuel to be for sure that that is his son.
Okay. Well, let's do this, and I guess I'll ask Mr. Matt.
Oh my God. Oh my God. I thought she was asking to test her to make sure that she was the mom. I thought it couldn't get any worse, right? Like, I really thought that's what she was asking for there. Wow. Okay. God.
Magnuson, if you could prepare an order for DNA testing and that the parties and the child would cooperate to accomplish that, we can get that done. That the order will remain in effect at this point until we get the results from the DNA testing.
I can do that, Your Honor. And I believe I heard Ms. Coleman indicate that Mr. Samuel had been moved to another facility.
She did early, yes.
Ma'am, if you could let me know what the name of that facility.
He just came back to Newaygo, in White Cloud, Michigan.
Okay, very good.
Okay, thank you.
Thank you.
Court will end this matter at 11:08 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
All right, our last case is Hunter versus
Last case.
Majarza, I don't know.
Sounds good. Please connect to audio.
I thought that was Dog the Bounty Hunter.
Okay,
All right, Alan?
Who fucked who in this situation?
Not sure. Doesn't have an option to connect to audio. Please connect to audio.
are you talking about me?
No, you're fine.
Okay,
The defendant, Alan.
I'm a terrible person, right? We're all terrible people, right? Together. Yeah.
we had trouble with this last time.
There we go. Oh, no, they connect here.
They were connected though, right, for a second?
I'm not sure. I think that was Betty. Did you just speak?
Yes, sorry.
Can you hear us? Can you hear us now?
The dude's name is Betty, MB.
Give them a few more minutes. If they can't connect, then we'll put it over and they'll have to contact
Please
us next week.
I think this is the second time
Yes, ma'am, this is the second time this has happened.
Well, you shouldn't fuck old men. Fuck somebody who understands how to use Zoom.
I'm giving them the telephone number and asking them to call in.
Yep.
And appear via telephone.
I am consistently impressed with people's ability to find the fucking worst angles possible. The absolute worst angles possible for themselves. It's uncanny because, you know, there's a lot of decent angles when you're using a phone or a camera, but it's literally every person's sort of like little kryptonite. I've just talked about this
Can you
before.
hear
How
us?
Shut up. I was gonna sell this, helped you do really well at Zoom court, but all it was some like a strapped onto the wall that you couldn't remove the phone from until after the court hearing. Yeah.
No.
That guy looks like he's wearing my fake rims. Glasses.
They haven't joined via telephone.
God damn it. These people are fucking killing me.
Seems like
Judge
we're
is
not
like,
gonna
I'm
get them to
finished.
connect one way or the other.
Well, I'm not.
Ms. Hunter, we've attempted to have the defendant connect vis-a-vis telephone, which is usually the easiest way to connect, and they're not able to do that either. So again, the court is required to make all attempts to get them to connect. So what we're going to probably have to do is, fortunately, adjourn the matter one more week, and we'll be in touch with them by phone and tell them how to connect by phone rather than by Zoom, because they're not able to do that apparently. So.
Yes, that's what happened. We've done this, I think, 2 or 3 times.
I understand, but well, we've done it once before, so we have to give them opportunity, and they obviously are trying to.
Audio.
Hello?
Yes, I'm here.
All right.
Okay.
Calling case 2022-255 DP Betty Hunter versus Alan Machazak. Today
Mike
is
Chuck.
Monday, March 13th, 2023 at 11:16 a.m.
Sir, just so I don't murder your last name, how do you pronounce that?
It's called Mike Chuck.
My Chuck?
Yes.
Okay. This matter is before the court on the defendant's motion to set aside referee order in this matter. Again, sir, we don't set those aside simply because you disagree with the ruling in the particular case, but you have to establish that there's a factual or legal error for doing that. So what do you believe to be the factual or legal error that the referee made in this matter?
No, I'd like the last time we hooked up, I wanted to get a DNA test. And my income, you guys got my income wrong.
Okay, well, let me tell you, again, that's why we have hearings, so you can come there and present that. You weren't present at the hearing. So, I guess I'd say, don't look at it as our fault that we don't have the income correctly when you don't appear at a hearing.
Okay, what hearing was that, sir?
The referee hearing, the one that this resulted in this order.
Okay.
Okay.
Ms. Hunter, are you opposed to a DNA test in this matter?
Yes, I thought he did it a long time ago, but I guess he didn't.
Well, okay. To say I thought it would, we don't know. Okay, if again, he's claiming that there was no DNA testing, what happens, the court will order DNA testing in this matter of the parties and the child. And I'm not going to do anything with the order until such time as that DNA is completed, because if the DNA shows that he is in fact the father, then there's no reason to change it. Court will order at this point that Mr. Marchuk would be responsible for the cost of that DNA testing. Mr. Marchuk, I'll tell you, you can contact the front of the court, and sometimes in some types of cases, they can assist in having that, testing done. So again, it's be a minimal, if any, cost in this matter, but I don't know if you fit with under the provisions whereby they would in fact accomplish that. So you're going to have to, what you'll have to do is contact the front of the court's office, talk to a Mr. Magnuson.
Okay.
He can tell you whether that would be something that the front of the court would do. Okay. If not,
okay.
If not, then you're gonna have to, again, then you're gonna have to acquire the DNA test yourself at your expense.
Okay.
Okay?
Yep.
Okay, we'll proceed to that point. That will be the order of the court. The court will end this matter at 11:19 a.m. You're free to go. Have a good day.
That's gonna be challenging, Your Honor. Lucky for us, there's just what, 3-4 minutes left in the day for my East Coast friends and 3 hours left in the day for my West Coast buddies. Guess what? I have more from that weird March. So we will be digging into the weird archives of March of 2023 in this court another day soon. It was a shit show. It's always a shit show, though. But it's our shit show. And I love y'all. Reminder, tomorrow's Thursday. I've been thinking it's like a day ahead, but tomorrow's Thursday officially. And we'll be back at it again with some sort of court. I hope that you've had a good time. Please make sure to like the video. It's super helpful. And reminder that I love you. I'm proud of you. And I will see you in the next video. Bye. Thanks, guys.